over the years, I've represented a lot of clients, significantly number of clients who've claimed that they've been beat up by the police either during the arrest or after the arrest for no reason. Believe it or not, this does happen in Ontario. Now, I'm sure some of those clients weren't telling the truth, but I know for a fact that others were because a judge found that to be the case. So what happens is in this situation, one of the most common areas that this happens in is impaired driving or DUI cases, I find. And I've handled a number of those type of cases over the years. So let's say we can show that the client sustained a broken nose or broken arm or other things like that. And we're able to demonstrate that the police did this without cause. They were just police brutality. Well, in this particular case, if you can demonstrate that in court to a balance of probability, if you think you can, and I've successfully done this in several cases over the years, you bring what's called you apply to bring a stay of proceedings under the Canadian Charter of Rights and Freedoms for abuse of process under Section 7, for example. Your rights have been breached. It's a difficult thing to pull off because you have to convince the judge that your client's version of events should be actually believed over the police. Like, it's your burden to prove that. You have to prove that to a balance of probability. And you also have to show that the force used wasn't just trifling. I mean, if the person received a bruise or two, they're probably not going to throw out a DUI. But if you can show it, that broken arm or broken nose or some bruising or some serious issues in this regard, you can. I had one case that the police didn't realize it, but they were being filmed in the background by a citizen, and that's how we won it. In fact, the Crown decided to withdraw that case, and I believe the police should have been disciplined in that case, but they weren't. So it's a tricky case to pull off. In many cases, I'll tell a client, look, there's 5 witnesses against you. We don't have any other witnesses. It's going to be a lot of money to defend that. It's up to you. But are you really going to be believed over 5 police officers? Well, it depends. I mean, if it's 1 against 1, sometimes we can win that case. Sometimes it's a numbers game if we don't have extraneous evidence. Of course, you often need physical injury evidence. And what do the police say in these cases? Of course, he attacked us first. We were, subduing him properly, using reasonable force, blah, 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 blah. Well, we've all seen those videotapes across North America. I have not represented a case that significant or serious, but I've been involved in some pretty serious cases, including broken arms and broken noses over the years, and I've won a few of them. I've lost a few of them too, which I thought, I understand why the judge would do that, because there was 3 witnesses testifying against 1, and the judge couldn't quite find that the accused version should be believed over the police officer to a balance of probability. So on this type of charter application, it's a different burden. The Crown's not proving a case beyond a reasonable doubt on the accused. It's the accused on a pretrial motion who has to show that the officers are essentially lying to a balance of probability and beat them up unwarrantedly. Now, if the judge finds that and finds there's an injury, for example, that's half significant, then they can stay the proceedings, which means effectively it's like it's dismissed. It's as if, it's a win. So, and that's done under what's called Section 24(1) of the Charter, where the Charter states. So that's an interesting, it's not a defense, but it's an interesting charter right in Canada, but it's a difficult thing to pull off, even if you are legitimately beaten up by the police. I mean, let's face it, a lot of judges prefer police word, unfortunately, over the accused in Ontario or in Canada, and that's just the way it is, unfortunately. And the burden is essentially switched. It's much easier to win a criminal case at trial with proof beyond a reasonable doubt that prove to a balance of probability that the police beat your client up. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.